Note 14 is really just a carrying on of what we have been talking about in Note 13, but it particularly goes into talking about secured transactions under Article 9 of the Uniform Commercial Code. Um, Terminology. Secured party is a creditor who has made a loan, has some type of contract, some type of agreement, and now holds security in collateral to make sure that that agreement or that loan is carried out or paid. The debtor is the person who owes money or performance to the creditor. The security interests are the rights held in the personal property of the debtor by the creditor to secure payment of the debt. A security agreement is a written document, very much like a promissory note in a mortgage situation or a credit card agreement, which basically states the relationship between the debtor and the creditor, defining the terms and also setting out the extent of the security interest in the personal property. Collateral is the personal property itself that is subject to the security interest of the creditor. The financing statement, this is the form that has to be filed with the Secretary of State's office in Rhode Island and Massachusetts to give notice to third parties that the creditor holds an interest in this particular piece of personal property. And the Uniform Commercial Code is a business law adopted by 49 states, regulates the sale of goods, regulates shipping and warehousing, secured transactions, some bank functions, particularly in the area of writing promissory notes and checks. Now, a security interest must be evidenced by a written agreement. The only exceptions to this are when there is what's called a pledge, where the creditor takes possession of the property and holds on to it. All right. The secured party must have given value. So there's no security interest that can be given to somebody unless there has actually been a transaction. That value has gone back and forth, that there's been consideration for those who have had contracts previously. And the debtor must be the owner and have rights in the personal property that can be assigned. If they don't own the property or they own it with someone else who they need permission from, then they cannot create a security interest. The security agreement must have a signature, seal, or symbol, or something on of the debtor on the document to indicate that it is valid, that is authentic. The debtor's interests can be something that he holds presently, or it can be something that they can be acquiring in the future. It can be an anticipated interest, and this gets very tricky. But if you think of particularly like buying and selling of agricultural products, you can create a security interest in your crop months before the crop ever is harvested, ever before it arrives. Um, Same thing supposedly with manufacturing goods. If you borrow money to begin a manufacturing process, you can give a security interest in the ultimate goods that are going to be manufactured by you, even though they're not yet in existence. Perfection, as we had said, it means in most cases filing the statement with the proper authority. In Rhode Island and Massachusetts, that's the Secretary of State, unless the thing is part of real estate. If it's real estate, then part one of the security, one of the financing statements must also be filed with the land evidence records in Massachusetts. Those are kept in the county courthouse. In Rhode Island, they are kept by the city and town clerks. And the records must be indexed by the name of the debtor so that anybody looking can go through the index and see what liens are there and are not there. And there's a whole series, if you look at the notes, there's a series of whose names must be listed and how, so that the indexing will be somewhat consistent and will allow somebody who's looking to see if there is a security interest or not to be able to find it. That's it for 14. Sweet and simple. All right, we are ending.